Now, answering your questions about the law and legal issues. This is Legal Break with attorney Gary Bruce.
Hello there. Gary, thank you so much for joining us as always.
Good to be here again. Thank you.
Yes, we love to do this segment and answer your questions. So we're going to jump right in. We've got a man on the street question, so let's watch and listen.
Hi Gary, what is the difference between assault and battery?
Well, it's a good question.
It is.
And I think it takes a little bit of background to answer. So
Okay.
what is assault and battery? Well, there's two different really arenas in the law, the criminal side and the civil side. I'm generally in the civil side. In the criminal side, it's about intent. You know, so an assault is an intent to cause apprehension, you know, to maybe
Right.
not to actually strike you, but to think you're going in trouble,
Okay.
think you're about to be physically harmed.
Okay.
So that would be the assault, and it would require intent. We don't punish people generally with criminal sentences for non-intentional acts. So you know, if you do
Accident.
something accidentally or don't mean to do it, that doesn't
Right.
mean you don't mean you walk away from it, but it doesn't mean you go to jail.
Yeah.
So that's the difference. So the civil side is the same. You have apprehension, but and it requires intent to be assault in a civil case as well. But if there's no intent, you don't get acquitted in civil. In the civil side, if you don't intend it, you still might be negligent.
Okay.
So your negligence could give rise to civil liability, and so that's what that's all about. You know, you may have responsibility for damages you cause.
Yeah, interesting.
So assault and battery, they change depending on
if it's criminal
whether
or
you
civil.
strike someone is battery, and an assault is the apprehension of being stricken.
Oh, very, very interesting and good question. We have this from a viewer question. Can I sue someone for having an affair with my spouse and causing us to divorce? Ooh, touchy.
Well, I think the answer in the old days was yes. You know, there was an alienation of affections cause of action. In Georgia in 1993, the Supreme Court held that was not a constitutional cause of action.
Okay.
So the answer now is no.
No.
You
Okay.
know. So, you know, that's kind of an archaic. We're trying to get away from fault so much, I think, in that arena too. But anyway, no.
Yeah, there's the answer.
I think that's the quick answer.
Well,
right.
two very good questions today.
Right.
Thank you so much for joining us, and
Thank
we
you.
look forward to seeing you on the very next Legal Break.